You can keep making your presentations even if I close the video and reduce the sound, because I may do it because of environmental disturbances, and you are not impacted by all that, so that our session doesn't get impacted. This we already discussed. There's nothing much in it.
Passage talks about the Elon Musk X Corp has filed a lawsuit against the Indian government
Yes.
and challenging its takedown order under the Information Technology IT Act. The case is being heard in the Karnataka High Court. X argues that the government is misusing the Section 79 Clause 3B to bypass the structure process outlined in Section 69A. Platform claim that the government takedown order lack transparency and create a parallel censorship, and the Indian government maintain that these orders are necessary for national security and public order. Contend that Section 69 provide more structured process for content and removal, including safeguard like reason, order, and opportunity to be heard. And X lost its safe harbor protection in 2021 for failing to appoint compliance officers, but later complied. And the Karnataka High Court has adjourned the hearing to July 1, allowing X to file the amendment to its petition. This lawsuit highlights the ongoing tension between free speech and government oversight in Indian digital space.
So Elon Musk's X, which was formerly called Twitter, is filing a counter lawsuit against the Indian government, citing the claim that uh, due to unlawful revelation and arbitrary censorship using using the Section 79, Article 3 of the IT Act, which allows the government to take down any online content if they think it violates the social norms or it may encourage crime. So what happens is that X in 2021 had protested against joining the Home Ministry's Sahyog portal due to its non-compliance. It lost its safe harbor in 2021. Now it claims that Indian government is overly restrictive and even targeting satire and journalists in its censorship program. So what they are arguing is that India should now the very part of the case is that the outcome the battle between Twitter and the Indian governments, which can result in a very different future for censorship in India. It can change how how online content is viewed, how much power the government has over what can be posted online, what can be seen online, and other statements and other views. Now, this also has some potential for diplomatic fallout since Twitter is owned by Elon Musk, who is a very close friend and ally of Donald Trump, and also has major influence in the US administration as of now.
Yes.
Between a social media platform which is X and its early name was Twitter and Indian government. In this article, it talks about that Elon Musk's social media platform X is in a real fight with the Indian government, and it says that the X says that the government is unfairly forcing it to remove too many posts and join a platform called SAO, which it clearly doesn't want to do. And the Indian government uses laws like Section 69A to block online content if they think it is dangerous or bad for public peace. And another rule, which is Section 79, subclause B, says that social media must follow orders to remove content or they will be held responsible for it.
This we have already done yesterday. There's nothing new in it. And the article is centered around of the Information Technology Act 2000. Information Technology Act 2000 in Section 69A says that you have passed an order giving certain directions to an online platform that is a social media intermediary. Certain conditions are fulfilled. What are those conditions? The conditions are that they should give a notice, number one. They should provide a hearing, and the grounds have been specified on which the notice has to be given and the hearing has to be provided, and then there has to be a reasoned order. So these are the safeguards that have been built into the I'll just do a screen share of section 69A of the company of the act so that the things become a little bit clearer. Yes, I've been able to open it and it's basically let me zoom it a little bit. Now it will be better visible to you. Yes. So can somebody read it out for me? Section 69A. This one. Can somebody read it out for me? Can somebody just read this? Read this 69A. Yes, Ram, can you read this?
69A. Power to issue directions for blocking for public access of any information through any computer resource. Clause 1. Where the central government or any of its officers specially authorized by it in this behalf is satisfied that it is necessary or evident in the interest of sovereignty and integrity of India, defense of India, security of the state, friendly relations with foreign states or public order, or for preventing incitement to the commission of any cognizable offense relating to above. It may subject to the provisions of subsection 2 was reasons to the record in writing by order direct any agency of the government or individual to block for access by the public or cause to be blocked for access by the public any information generated, transmitted, received, stored, or hosted in any computer source. Clause 2. The procedure and safeguards subject to which such blocking for access by the public may be carried out shall be as may be prescribed. Clause 3. The intermediary who fails to comply with the direction issued under Section 1 shall be punished with an imprisonment or term which may extend to 7 years and also be liable to fine.
So you have read this. Now, section 69A, what all things the government has to do to pass an order under section 69, either the government or any other authority, judicial authority. What do they have to do? What is the minimum required under this? Reasons have to be recorded in writing before the government issues any direction under this provision of section 69A. So reasons have to be recorded in writing. That means, and where is it written that the reasons have to be recorded and what are the procedures that is specified in the rules. So rules will prescribe the procedure. And what do the rules provide? Rules provide the same thing, but how it is done, that only is being stated. So that is not very material. So I'm not referring. They will say that you have to provide the notice and so many days you have to provide for the reply. After the reply has been filed, you have to give a reasoned order. That is already written here. Reasons to be recorded in writing. So the rules will prescribe a procedure as to how you implement section 69A. So section 69A requires that a notice should be issued to the person. And what is a notice? Notice should contain the grounds on the basis of which an order is proposed to be issued by the government. All right. Now, you will be required to reply to that notice. You will be given an opportunity to reply to that notice. If the government is satisfied with your reply, then the direction will not be issued and the notice will be set aside. If the government is not satisfied with your reply, then in that case, the government will issue an order. So there are two courses of action which are available to the government. One is it is satisfied with your reply, and secondly, it is not satisfied with your reply. And the treatment in the two courses of action will be different. One leads to nullification of the notice, another leads to passing of the direction. So what this article is talking about is that the procedure under 69A has not been followed. What are the grounds? The grounds are these: interest and sovereignty of India, defense of India, security of state, friendly relations with foreign states, public order, or for preventing incitement to the commission of a cognizable offense. So these are the grounds. And the same restrictions are there under Article 19, Clause 2 of the Constitution. The same have been reproduced here. Sovereignty and integrity of India, defense of India, security of state, friendly relations with foreign states, public order, or for preventing incitement to commission of an offense and all. These are basically the grounds which are specified as reasonable restrictions under Article 19, Clause 2. The same have been prescribed here also. Now, if this kind of notice comes containing these grounds, And the grounds, don't confuse the grounds with facts. Grounds are conclusive statements of facts. They don't give the material facts. They will contain only the material facts. They will not contain each and every fact. That is a ground. Broadly, they will state that these are the reasons why these reasonable restrictions have been violated. And because of this, we are issuing a notice that you cease from it. And once you cease, once you take down, then you are protected. That is the safe harbor immediately. Then let us have a look at section 79. Clause 3B. What is it, sir? Can somebody read it? 3, section 79. This is section 79. And this is, please read this. Notwithstanding. First you read section 79, clause 1, then please come to 3. And after 3, please come to 3B. Can somebody volunteer? Or it will fall off the Rayan only to read it. Yes, Rayan, please read. Section 79.
Section 79. Exemption from liability of intermediary in certain cases. Clause 1. Notwithstanding anything contained in any law for the time being enforced but subject to the provisions of subsections 2 and 3. An intermediary shall not be liable for any third-party information, data, or communication made available or hosted by him. Clause
So there is a total exemption from liability, provided you comply with what is written in subsection 2 and what is written in subsection 3. And what is written in subsection 3, which is relevant for our purposes, please have a look.
The provisions of subsection 1 shall not apply if A. The intermediary has conspired or abetted or aided or induced, whether by threats or promise or otherwise, in the commission of the unlawful act. B. Upon receiving actual knowledge or on being notified by the appropriate government or its agency that any information, data, or communication link residing in or connected to a computer resource controlled by the intermediary is being used to commit the unlawful act. The intermediary fails to expeditiously remove or disable access to that material on the resource without vitiating the evidence in any matter.
Yes. So these are basically two provisions, section 69A and section 79 3B, which are the bone of contention between the parties. This provision, the proviso of subsection 1 shall not apply if. And what is the proviso of subsection 179? 1 shall not apply. The provisions of 1 shall not apply. This is what one says, that an intermediary shall not be liable. When an intermediary shall not be liable, this is when it is. Upon receiving knowledge or being notified by appropriate government or communication link residing or connected to a computer, resource controlled by the intermediary is being used to commit unlawful act, the intermediary fails to expeditiously remove. So if you fail to comply with the government order which has been passed, or fail to comply with the court order which has been passed, then you will be held liable. You will be held liable alongside that. Otherwise, you are exempt from liability. Now, what X is saying is that under section 69A, you are required to record the reasons. Before recording the reasons, you are also required to issue a notice. The notice must contain the grounds based on which the direction is being issued to you. Then you are given an opportunity to file a reply. And the reply may be acceptable, may not be acceptable. If it is not acceptable, then an order order for blocking or taking down the material will be issued to you. Now, where is all this? Under section 79. When you are issuing an order under section 79 3B, that upon receiving actual knowledge, we are being asked to do this, but you don't comply with 69A and straight away issue an order under 79. That is the entire bone of controversy between the parties. Yes or no? Because this is an important thing. This is in news very prominently, and you should not be surprised if it lands up in the examination also. So be very clear in our mind to understand it crystal clear, so that when the question paper comes, you already know what is this drama about section 69A, 79 3B. All this is already, you are already aware of this, and you will save critical moments for other questions. So be very, very, very clear in your mind That is why so much time we have spent on it. This is just too important to be. This is just jumping out of the newspapers at us, and therefore we should be very, very clear about it. Is that clear? If this is clear to you, then Priyanka, tell me what is clear to you. Priyanka, tell me what is clear to you under section 69A and section 79(3)B. What is clear? What is the clarity? Tanishka says, I'm not able to listen to my voice. All right, doesn't matter. So, Priyanka, what is clear to you? Can you tell me? Can you just summarize?
Look, online content that it thinks is dangerous or bad for public peace, and that can harm our society and cause public unrest. And section 79 subclause 3A subclause B says that social media must follow the orders to remove content or uh, remove content the orders given by the government, and if they don't comply to the orders they will be held responsible for it.
Yes. And what is section 69A saying?
Block access to online content
Sir,
if it violates any national security or may have an issue with sovereignty of the state or harm public order.
So you will be entitled for a notice and the communication of grounds, and you have a right to reply, and the government has to consider your representation, all that, right? So this is what section 69A is saying. So the main thrust of the argument,
Section 69A gives the Indian government the power to block websites or online content if the content is seen as a threat of India's security, sovereignty, integrity, public order, or friendly relations with other countries. And it can use this power to prevent possible crimes that can happen.
yes, you have
So
summarized
that's all from my side.
You have summarized section 69A, but you see section 69A, insofar as it is relevant to us, also contains one other thing, and that is your entitlement to notice, your entitlement to reply to the notice, entitlement to receive the grounds based on which the government is interested in passing an order against you, and your entitlement to the representation, your representation being considered by the government. All these items of procedure have to be actually followed before an order can be passed based on the provisions of section 69A, that the sovereignty of India, territorial integrity of India, the defense of India, the public order, friendly relations with other countries, or incitement to an offense. All these things are involved, and an order is being passed on these grounds only. If an order is not being passed on these grounds, then order is liable to be set aside. If these big grounds are not are not included in the notice to which you have to give an explanation, then the notice is liable for quashing by the court, right? So 69A provides a procedure. The rules outline the procedure in greater detail, and 79 is in terms of a summary kind of provision, wherein the government's power is enshrined that the government may pass a blocking order in but it does not specify the procedure by which the government will pass the blocking order. The procedure is specified in section 69A. Now the problem, where the problem lies is that section 69A prescribes the procedure. The problem comes in when the procedure is not followed by the government. And instead of following the procedure, straight away an order under section 69 is passed. You following? Where is the rub? The rub lies in this, that the government passes an order without following any procedure. Straight away it says, nothing doing, you take down these sites and all that. That is where the problem comes in. Upon receiving knowledge or being notified by the appropriate government or its agency, then what you have to do, if you fail to expeditiously remove or disable access without vitiating the evidence. So safe harbor will not apply to you if you fail to act. So Section 79, using Section 79, Clause 3B, the government is able to circumvent the requirement of following a procedure before a binding order is passed. I hope this is amply clear to you. This is the crux of the dispute between Elon Musk's asks and the government of India. They are saying, please follow your own rules. You have to follow your own rules. You have to follow the procedure prescribed under Section 69A. Now the question arises, why the government does not follow the procedure under 69A? Does it not know that there is a procedure which has been enshrined? How can the government not know? It is their law after all. They have passed it. I know that the parliament is supreme, and the parliament, it is not the parliament which is supreme, it is the constitution which is supreme, under which the parliament is also constituted. But the point is that when the government is already aware of Section 69A, then why does it resort to Section 79, bypassing the provisions of Section 69A? The reason is very simple. Section 69A limits the government. You must have read in your working of the Constitution, in your class 11, that one of the functions of the Constitution is that it provides a limited government. And that is exactly what Section 69A does. It makes the government follow a procedure. It limits the grounds the government may pass a binding order, or a banning direction, or a takedown order, or a blocking order. It limits those grounds. In other words, it imposes a limitation of the government, and no government or no ruler likes those limitations. Although in the parliament they may have framed those rules and regulations and all that, but when it comes to actual practice, those are the ones which are sought to be given the go by the government at the helm. So that is why, because power corrupts, absolute power corrupts absolutely. That is as much correct today as it was when it was first spoken, I guess, by Aristotle or somebody else, or Socrates, I think, whoever said so, but it is as relevant today as it was when it was first spoken. Having said that, let us very quickly come to the questions that we have to handle. 112 question has been marked correct by everyone, so I'll take it up. An online gaming platform. I have some problem with my somebody volunteer. All the time I ask Rayam to read it in default. Somebody else can also volunteer.
Question 112. An online gambling platform was found hosting malware-laced advertisements that infiltrated users' devices, stealing sensitive data. The Ministry of Electronics and Information Technology issued a directive under the Section 69A of the IT Act, instructing the platform to take down such advertisements immediately. On what grounds can the platform refuse to comply with the government directives?
The government passes an order, a direction. The platform says we will not comply. What in the law provides them the liberty to say so? The liberty to refuse. A. Directive violates the platform's freedom of speech and expression under 19(1)(a) of the Constitution. Platform is only an intermediary. So this may be slightly off the cuff. Platform is not the what we call as the main creator of this thing. They are only hosting it. And why are they hosting it? For advertisements. For advertisements. Why for advertisements? Because that is the revenue generation. That is where the revenue generation comes in. So freedom of speech and expression, yes, platform also has. It's not that platform doesn't have. Surely has, but seems to be very far. Then government has failed to provide valid reasons that align with the provisions of Section 69. Yes, this is correct. Because Section 69A says that you have to record the reasons. For that, you'll have to give the notice. For that, you'll have to invite the reply. For that, you'll have to consider the reply. And then you have to pass the directions. You cannot directly pass the directions. And here, no notice has been issued. So the option B seems to be the correct option. Third is the platform believes its internal policies override a legal framework. This can never happen because the internal policies cannot trump the law. It is the law and the rules which trump the internal policies of any company or any entity or any organization that has powers, that is clothed with the personality, with the legal personality under the law. Now, the directive was issued without following due procedure outlined in the IT rules 2009. This also seems to be correct because you have to follow the due procedure as outlined in the IT this thing, right? So B and D appear to be the correct. One directive violates platform's freedom of speech and expression. The notice has been issued under Section 69A of the IT Act, and Section 69A provides the right of hearing, the right of the representation being considered, the right to a reasoned order being passed by the authority. What is the significance of all this? Limitations on the government, limitations on the arbitrary powers of the government, right? So this B and D appear to be directly relevant to the issue. This one this of course it is important, but in the given circumstances, this one B and D appear to be. Then this 100% correct. 114 is 100% incorrect. So we will take it. This is 114. An equipment rental service handy equip unknowingly rented machinery to a construction company operating without necessary permits. It received a notice from the municipal authority containing a direction to immediately cease its rental agreements. What options does handy equip have against the notice to escape liability based on the safe harbor principle? Equipment rental company unknowingly rented machinery to a construction company operating without necessary permits. All right. It received a notice from the municipal authority containing a direction to immediately cease its rental agreements. What options have against the notice? Yes. So the construction company was operating without the necessary permits, and certain equipment which should not have been rented out to them was rented out to them for construction purposes, for which they did not hold a permit. So the notice comes from the government. What are the options? Prove that it had no prior knowledge of the construction company's lack of necessary permits, that it was in good faith, otherwise it will come in bad faith. Demonstrate that it acted promptly to terminate operations. Yes. After all, that is exactly the essence of the safe harbor principle. Safe harbor principle is that once I came to know about the problem, I immediately took action to carry out the corrections or rectifications. That is the safe harbor principle. Then you are not held answerable for the content. Same applies here. The moment I came to know about the absence of permit, I ceased my connection with them. Right. So this is the safe harbor principle coming into operation. Argue that the notice violates its contractual agreement with the construction company. Now, notice, which is a government notice, cannot be deemed to violate the contractual agreement because there is no question of any violation. It will simply trump. It will simply ride roughshod over. It will simply set aside the contractual agreement. It will not take any notice of the contractual agreement. Private law cannot bar. Private law as contained in the contract between the parties, because that contract is a private law between the parties. It will be enforced. When the court sits to adjudicate the rights of two parties, and courts take cognizance of what they have agreed upon. That is private law. That is the law between the parties. But private law can never trump the public law, which is contained in the law, which is based on legal provisions. Highlight that it has implemented measures to ensure compliance verification for future transactions. So A, B, and D seem to be the correct answer, whereas C seems to be contrary to the what we call as the law. That's why it's not the correct answer. 115 fully correct. 116 I will not take up, fully correct. 117 also the same. Then I can go to the next legal reasoning passage, which is given in, which is passage number 17. Please read passage 17 and tell me what is written there. This is interesting because this is in response to what Justice Yashwant Sinha has, Samashi Yashwant Verma has. I don't know. Yes.
So this passage talks about just Justice Yashwant Verma of Delhi High Court is under investigation. This after this large number of cash were discovered at his residence during a fire control operation, and the CGI has performed three members in a House committee to probe the allegation. And firefighter found the burnt currency note in a storeroom at the Justice Verma residence, but Justice Verma denies placing the cash there and claim he never showed the burnt currency. The CGI has appointed the Chief Justice from Punjab, Haryana, Himachal Pradesh, and Karnataka High Court judge to investigate. And Justice Verma has been transferred to the Allahabad court. His judicial duties has been suspended. In House inquiry process, the Supreme Court in House established in 1999 allow for internal investigation into judicial misconduct. In misconduct, the judge must ask to resign. They refuse. If they refuse, the president and prime minister are informed for parliamentary removal proceeding. And this case raises serious questions about judicial accountability and transparency in India.
Yes, Ryan. Yes, Priyanka.
So this passage talks about a recent case in which Justice Yashwant Verma of the Delhi High Court is under investigation because during a fire at his house, a large amount of burnt cash was found, and he said that he and his family didn't put the cash there. Now the investigation is undertaking, and now the Chief Justice of India has formed a three-member committee to investigate this under the in-house procedure, and Justice Verma has been transferred to the Allahabad High Court, and judicial work has been taken away from him. And in-house procedure is it is a system created by the Supreme Court in 1999 to handle complaints against judges, and this passage also talks about how if a complaint seems serious, a committee of judges formed, and then the committee decides if the misconduct is serious, and if the misconduct is serious, the judge is asked to resign, and if the judge refuses to resign, the matter goes to the president and parliament for impeachment. And this investigation led to the many concerns. Some of them are that these in-house inquiries should be made public, and even if the judge is found guilty, they have to be punished criminally, and it also says that the collegium system for appointing judges is seen as not transparent. So some want to bring back the National Judicial Appointments Commission with improvements.
Yes.
So this paragraph is about the bundles of cash found at the house of Justice Yashwant Verma of the Delhi High Court, which was during a fire incident where the firefighters uncovered a large amount of burnt cash as residence. So while Justice Verma and his family has denied any involvement in cash, claiming that the cash was not placed by him or his family, the Chief Justice of India has formed a inquiry with a three-member committee of senior judges to investigate the allegations of sexual misconduct. Now, with the inquiry pending, Justice Verma has been stripped of his judicial responsibilities now and has been transferred to the Allahabad High Court. While the in-house inquiry is confidential and cannot impose criminal penalties, it, however, can recommend resignation or the removal of the judge. This case really highlights the lack of public disclosure and lack of transparency in Indian judiciary, and that greater transparency and accountability must be established.
So, before I make any comment on this, I will draw your attention to a similar instance which had happened uh, a couple of years ago, wherein a briefcase full of cash was left at the door of one of the judges, who was, I think, at that time the principal district court judge. And if the two judges were involved in this, one was, I think, a High Court judge, another was I guess, a district court judge. And the cash, bundle of cash stored put in a briefcase, was found at outside the residence of one of the, when investigation took place as to how the cash landed, the judge concerned saw the cash at the door of her residence. She took the cash inside and she found so much cash is there. And she called the police and she asked as to what is this going on, how the cash has landed up at my residence. Then the investigation was carried out. The cash was meant for some other judge. The problem was the names of the two judges were more or less similar. One, if I remember correctly, was Nirmaljeet Kaur and another was Nirmal Yadav. So what was meant for Nirmal Yadav reached the residence of Nirmaljeet Kaur, Justice Nirmaljeet Kaur. And Justice Nirmaljeet Kaur initiated the investigation. And now a recent newspaper, as per newspaper reports, the judge who was involved, she has also been acquitted. So to who does the cash belong? We have no answers. Today also we don't have answers. After nearly 2 decades of the cash having been discovered and being investigated by the police, we have no answers. So what does it point out? Because justice is a very serious business. If the justice is absent in the society, there can be chaos, there can be anarchy, there can be riots, there can be lawlessness, there can be many things which should be avoided, which are not conducive to a proper, a civilized society and a civilized interaction in such society. Therefore, justice has to be pure. It has to be pure and pristine. Its purity has to be maintained. And how can you maintain its purity when you don't have a robust mechanism for institutionalized mechanism of accountability? Whether it is the police force, whether it is the administration, or for that matter, whether it is the judiciary, whatever it is, the accountability has to be there. Purity of the public discourse has to be maintained. How do you do that? This article highlights the requirement of purity and how the pure has become profane. This article is an example of the same. Now, administration and the police force, these are important institutions of the government. Governance has a third important institution, which is the judiciary. When we deal with the judiciary, then we have to be extra cautious because independence of judiciary is the cornerstone of our constitution. Therefore, we cannot, like in case of an ordinary investigation, let the police force loose on the judges and do as they would. That is not permissible because judiciary has the only weapon in its hand is its reputation. If its reputation is easily belied by the administration or the executive or the members of the police force, then in that case you can't save the constitution, you can't save the democracy. Therefore, judges have been given a very sanctimonious position in the Constitution of India because they have the very onerous responsibility, very big and high responsibility, which is institutionalized through our Constitution. Therefore, they have to safeguard the democratic functioning of the government. They have to enforce the provisions of the government. They have to keep the union and the states from encroaching on each other's powers. Therefore, they have very important functions to discharge under the Constitution of India. Therefore, corresponding to the importance of the functions that they perform. The safeguards have been built, institutional safeguards have been built into the Constitution of India, and which gives judges from the legal process. And this immunity was amplified in terms of the institutional procedure, in-house institutional procedure, and it was made public subsequently in 2014. And what is that institutional procedure? The institutional procedure is that when you have issues of accountability against any judge of the higher judiciary, be it of the High Court or be it of the Supreme Court, then in that case, the allegations against the concerned judge would be brought to the notice of the Chief Justice of India, who will take the steps and who will constitute a committee. And there will be an in-house inquiry committee, firstly by the High Court judges and secondly by the Supreme Court, depending on the findings of the High Court committee. Now, in this case, a High Court committee has already been constituted, and the High Court committee is yet to submit its report. Against this institutionalized in-house procedure is that you make it a little transparent. At least let the findings of the committee be made public, which seems to be a legitimate demand. Now, secondly, stage is reached when the findings arrive, and the findings arrive, suppose they can either exonerate the judge concerned, or they can say that the judge, there is reason to believe that he is guilty of misconduct. If this kind of thing happens, if the second thing happens that he is guilty of misconduct, then in that case, a further course of action has to be taken, and the next round of investigation is a Supreme Court, a collegium, a committee of the Supreme Court judges will investigate the issue. And thereafter, the judge concerned will be asked to whether he wants to tender his resignation or whether he wants to fight it out. And if he wants to fight it out, then the matter will be referred to the parliament, and where the political process will be sent into motion. And the resolution containing the provision for removal of the judge will be passed in each house of the parliament. And there's a majority, special majority, that is required. I think 2/3 of the members present and voting, and 50% plus one vote of the total majority. So that much is required. And that is, many times it is not easy to collect together such huge numbers of parliamentarians, because the voting takes place on political lines, right? Even if it is passed in one of the houses, it may be obstructed in another house, and the matter would come to an end, and the judge would escape without accountability having been imposed on him. In this regard, the author has talked about the National Judicial Accountability Commission, Judicial Appointments Commission, which was instituted, or rather sought to be instituted by the government, but which was struck down by the Supreme Court by saying that the bill basically gave the privacy to the judges, privacy to the outsiders in appointing the judges. And therefore, the present system of judges appointing the judges is continuing. Now, nothing wrong with the judges playing a role in appointments of members of the higher judiciary. This is the practice prevalent in other parts of the globe also. But it has to be, there have been demands for broad-basing the system. And in this context, the author makes a very relevant point that you broad-base the system in such a manner that you take into consideration the concerns of the judiciary for the independence that they have under the Constitution. And such independence has to be given the respect and has to be given the deference that the Constitution framers have rightly appointed for it. And how do you do that? You can do it by giving the judges the privacy, but involve people from outside also. That is what the NJSC, the National Judicial Appointments Commission, was struck down by the Apex Court in the year 2019, primarily because it gave privacy to the outsiders. Because if there was a disagreement between the judges. Then the two eminent experts which were to be appointed by the by the by the law ministry, I guess, and there was a nominee of the law minister. There were three of the committee from outside. And if one of the judges disagreed that the government and its nominees will have the majority in the committee, and that was one of the grounds why it was considered to be the HJC was considered to be. So this is basically the article what it talks about, right? Independence of judiciary is the cornerstone of the constitution, and that has to be honored. And nevertheless, accountability in any institution, if it is absent, then that institution will only see decadence. It will decay away. There will be once again the same proposition would apply. Power corrupts, absolute power corrupts absolutely. An institution without accountability is unimaginable. It is unimaginable the extent to which it can deteriorate in its function. The moral decadence, the moral degradation, the moral deterioration of such institution is anyone's guess, right? So accountability is a must, but at the same time, judicial independence is equally a must. Both of them are equally important, and both of them have to be respected in the light of our peculiar constitutional history, where the executive has, whenever it has been in the power, it has made attempts to evolve a system of competent judges where the judges will barely toe the line of the government. One such experiment was carried out during the emergency by the government, and when the Allahabad High Court struck down the election of the Prime Minister, and this was one of the events why the Prime Minister imposed the emergency, and during the emergency, all kinds of excesses took place. And the judiciary, in the ADM Jabalpur's case, which is said to be the most infamous of cases decided by the Indian Supreme Court, just like one of the earlier cases decided by the US Supreme Court, where they said that slavery is constitutional, just like the United States Supreme Court gave that kind of ruling. Our Apex Court also gave a very famous ruling in the ADM Jabalpur's case, where Justice Khanna was the sole dissent on the bench, and for which a grateful nation decorated him with the highest civilian award of the country, because of his stand that rule of law cannot be suspended even during an emergency. So we have to, before any recommendation is made, we have to also be cognizant of the constitutional history that we have, how fragile is the balance between the institutions, and how a powerful executive can override the concerns of constitutional limits that the present judiciary and the future judiciaries will continue to have. In all these, the only by balancing all the considerations coming to mind, the only just and fair seems to be that there has to be accountability, but at the same time, the requirement of balance between the institutions has to be respected, and that can only be done if the judiciary is truly independent. So after having said that, I will go to the questions for after. Yes, I take up question number 127. Here, the principal district court presided by a female judicial officer of these Hazari courts leveled certain accusations against his senior colleague. Inquiry was constituted, and High Court of Delhi this thing. All this has been done. Actually, now the question is, the inquiry committee submitted its report. Whether the report can be challenged? Yes, the report can be challenged, because this in-house procedure is not extended to members of the district judiciary. It is only applicable to the members of the High Courts and the Supreme Court. Is that all right? Okay. So this is contrary to the legal propositions contained in the passage, because the in-house procedure applies only to the members of the higher judiciary, not the members of the district court judiciary. Now let us come to question number 128 once again. 50% responses are incorrect and 50% responses are correct. Delhi High Court, presided by a female judicial officer, leveled an accusation against the principal family court judge of these Hazari courts, who happens to be female. The allegations leveled by the High Court is of inappropriate touch. An inquiry committee is constituted with judges from Delhi and Bombay. The process was conducted confidentially with considerations for the victim's dignity and safety. The committee examines the allegations and gives its findings, holding the charges as proved. The accused just challenges the findings, whether the findings can be sustained. Yes, they can be sustained because the judicial officers are not of that class. Because one of the judicial officers is this is High Court, and another one is of the High Court. So, female judiciary allegations High Court is not appropriate touch and inquiring of instituted. All of whom are female. Process was conducted. Here the problem is slightly different in this instance. High Court judge is the complainant, whereas the in-house inquiry committee which has been constituted is what? High Court judge is the victim of all this, right? Whereas the in-house committee which has been constituted is for the benefit, for the protection of the judges, right? Here the High Court judge is himself the complainant. He himself is the victim. So this will not be applicable. Then there is a lawyer lodged a formal complaint. This is 100% correct. So I need to. The retired CGI was accused of plagiarizing in his arbitral argument judgment. This I drafted because you must be knowing that Chief Justice of India, Justice Deepak Mishra, one of the arbitral awards that he has written was set aside recently by the Singapore High Court on the ground that he had copied and pasted certain provisions of the arbitral award from his own judgments, own writings. They said that no, this is bias. Right? They said you can't do that. You can't when you are sitting as a judge, then you have to apply your mind independently. You can't do cut and paste. They said that this is prejudging, this is prejudiced, this you already have a conceived bias, conceived notion. Therefore, miscarriage of justice has taken place. And they set aside his arbitral award. This was splashed across the social media. This was all over the media just a couple of days ago. Very, very unfortunate for the concerned judge. Justice Deepak Mishra is a very great judge. I have appeared before him several times. Very, very courteous judge on the bench. Very, very gentle and very passes very nice orders. All that I was really very, very pained to see these kind of observations. From his own his own judgments he has taken up, but then law is the law for everything. Anyway, a retired CGI was accused of plagiarizing his arbitral award judgments research published in certain reputed academic journals. The inquiry committee conducted a thorough investigation. They concluded that the misconduct was serious. What would be an appropriate punishment to the accused judge? Now, the question of punishment does not arise in this case because it is a retired former CGI. Whereas the in-house counsel, in-house procedure which has been instituted has been instituted for serving judges, not for retired judges. Though in some cases, for example, Justice Ganguly of the Supreme Court, retired Justice Ganguly, he was sought to be investigated by the police, and he before the FIR was lodged, the Supreme Court did conduct an inquiry, in-house inquiry, and they called Justice Ganguly to examine whether the allegations against him were correct. They found substance in those allegations, unfortunately, and the FIR was allowed to go forward. But that is a slightly different case rather than the present case, right? Now let us come to the next one. Yes, Waqf bill. We'll finish this today. So very quickly go through the Waqf bill. There are just 3-4 points that are there in this. And tell me those points. We do the questions and we wind up. Yes.
So this passage talks about the Work Amendment Bill 2024 has sparked a significant controversy in India and opposition parties and Muslim organization criticizing an attack on constitutional right, an attempt to politically polarize society. And there is a concern the bill allow non-Muslim member to be appointed to state work board which critics argue interfere with the religion autonomy. And the district collector is a given power to determine the ownership of the disputed work property, replacing the work tribunal, raising concern about why. And the bill eliminates the concept of work by the user and potentially affecting the mosque and graveyards that lack formal documentations. And all work properties must be registered on a central database within the 6 months. And bill removes the finality of the work tribunal decisions, allowing them to take challenge in the High Court, which could lead the legal battles. Constitution and a move to keep a society permanent polarization. The nationwide protests have been announced with some organization boycotting the and the Supreme Court has issued the interim stay on certain provisions, including the appointment of new work board member. The bill intensified debate on the religious autonomy and the government oversight in minority rights.
So this passage explain why the Work Amendment Bill 2024 has become controversial and why many people are opposing it. So this passage gives the five key reasons for that, and first of them is uh, the non-Muslim members, uh, because the proposed amendment will provides it allows the non-Muslim to be part of the work boards, and which many feel should only involve Muslims only, and the second reason is government decides disputes. This and the second reason is government decides dispute. If a state officer uh, now the state officer can decide if land is work or government owned. Raise bias concerns there, and now the property is used for third reason is that now property is used for religious purposes without the legal papers may no longer be protected, and the fourth reason is WAF land must be registered online within 6 months, or the or the right to go to the court may be lost. And the fifth reason is that tribunal decisions can now be challenged in High Court, reducing their final authority. And the conclusion of this passage is basically that these changes have caused concern among Muslim organizations and the opposition, and they believe it could harm religious rights, and it can lead to the unfair decision, and this bill is still under debate and discussion. That's all from my side.
Yes, they are.
So this article is basically about the controversies that the Waqf Amendment Bill has sparked, and many critics say it will undermine the Muslim religious institutions. So the key issues raised in this article about the amendment are it addresses non-Muslim implementation. So a non-Muslim will be appointed as the CEO, and members of the Waqf board have begun to challenge the religious character of the Waqf institutions. Due to this, government officials will have more power over Waqf tribunals over deciding whether a land is Waqf property or not. Previously, a Waqf tribunal would decide if the land in question is a Waqf property. The Waqf by user amendment will be removed. So this was a part of the Waqf Act 1995. This allows, let's basically say, a long-standing religious property will be Waqf by default. So a masjid, for example, will be Waqf and does not need a Waqf tribunal to recognize as a Waqf property. And all Waqf properties will now, it's now mandatory to register all Waqf properties with the center, and any failures in doing so may result in legal recourse or disputes. Work tribunals rulings can be uh, reappealed by appealing in High Court. Before this was not possible, and that the decision of the work tribunal was deemed final.
Yes.
So these are the main key issues in this article.
Yes. So basically, this provision of the law, which is the Waqf law, the subject of debate, much time has been spent on it in the Houses of Parliament. And basically, these are few of the contentious issues which have been argued, debated in the apex debating forum of the country. Basically, number one, that a non-Muslim has been made as the head of the tribunal, Waqf tribunal. Does it make a difference? Does it make a difference as to who is the judge? Or does it make a difference as to which community a judge belongs? Whether he is a Muslim, whether he is a Hindu, whether he is a Christian, whether he is a Parsi, or whether he is a Zoroastrian, or he belongs to the Buddhist faith. Does it make a difference? It has to go by the rules of the law. What difference does it make? Why only a Hindu should be appointed in a dispute between a Hindu and a Muslim, or between why a Muslim cannot be appointed? Why not? What is the difference? What is the issue? There is no issue. To my mind, there is no issue. But that is earlier the Muslims only used to be appointed as the chairman of the Waqf tribunal. But this is a debate without any substance. Because you see, if in the World Bank we have one of the World Bank or IMF, I don't remember exactly. There is a person of Indian origin who is in charge. Does that really make a difference? Except for having a satisfaction that an Indian is in charge, makes no difference as to who is the judge. Because the judge is powerless to play it community-wise. He doesn't have the powers to do that. If he does, his judgment will be liable for cancellation in appeal. So it makes really no difference as to which community a judge belongs to. It is hardly of any significance. Doesn't make any sense, right? Because he has to decide as per the law. If he doesn't decide as per the law, the judgment itself becomes questionable in the eyes of law. And surely there's a high chance that on appeal at some forum, in some appellate forum, it will be struck out. Second power which has been given is the second thing that it concerns is the work by user. Now there is a law of prescription that if you are there in a property for a very long period of time, without any contest, without any objections from any quarter, that property is yours. They call it property by prescription or property by adverse possession. From time and again, the Supreme Court has aired its views that why the adverse possession should be recognized in the law. They have stated that adverse possession should not be recognized. Once it is illegal for 1,000 years also. What difference does it make? Why merely because somebody has been into adverse possession for a couple of decades, say 20 years, 2 decades, then why the ownership should change? Merely because somebody has been in adverse possession. Work by user says that if a property is continuously under the use as a mosque, then suppose for 1,000 years the property is being used by members of a particular faith, whether of Muslim or whether of Hindu faith, then such prolonged use of over generations, several generations, by the adherents of a particular faith will give rise to ownership of the property. That if you are into possession of a property, suppose some ancestral property of yours, and you don't seem to have the documentation, but you have the possession, and nobody seems to have the documentation, you can't be deprived out of your possession, because possession is 9/10 of law. Only one person is superior to you, and that is the real owner. If the real owner can put up his title, then the possession can be defeated as an incidence of ownership. The ownership will go to the real owner. So possession, since it is 9/10 of law, then what is wrong if Waqf is in use and if Waqf property is being used for times memorial, then why it should not be given impact? It should be given its due. So that is the second point. Third point, they are saying that the findings of the Waqf tribunal were earlier, there was no appeal which could be made against the findings of the Waqf tribunal. But now the findings have become subject of an appeal. There's nothing wrong with their having subject of an appeal. Nothing wrong with that. What is wrong in having an appeal? You surely can have an appeal against any order. Suppose an injustice is done, then why it should not be allowed to be cured in appeal? There should be liberal appeal provisions. In fact, that to that extent, the provision of law is quite progressive. It cannot be objected. Waqf by user, yes, you can say that. That may be slightly, an overreach, but rest of the provisions may not be, objected to. So this is what this basically talks about. I'll quickly run you through the questions, and thereafter we will come to question number 131, legal reasoning. 131 says, assume this is 100% incorrect. There are only two questions in this. Assume the government introduces the 224 bill and the same becomes law without the amendments, as discussed in the above passage. The Waqf Tribunal constituted 2 years ago has given a ruling which decides that certain immovable properties are charitable in nature and belong to the place of worship with which they are associated. The petitioner intends to challenge the Waqf ruling. The respondent argues that taking an objection about that the petition is not maintainable. Decide on the maintainability of the petition. So what the question says is there was a determination 2 years prior to the recent law that has come into force that a certain property was a Waqf property. Now they want to reopen that. Is that allowed? Can it be heard repeatedly more than once? Is it permitted at law? The answer is no. What bars it? The principle of res judicata. That matters once decided cannot be re-litigated. Go in appeal. You can't reopen the matters which have been decided in one forum. Is that clear? Second question. Assume for the sake of discussion, the new amendments have seen the light of day. The old Waqf tribunal extended before the new amendments came into force, gave a ruling in favor of the members of the Muslim community that a certain immovable property belonged to them, but without support by any documents. The ruling was given prior to enforcement of the proposed bill of reconstituted Waqf tribunals. However, after the coming into force of the provisions thereof, the government makes a reference to the newly constituted Waqf tribunal about certain aspects of the dispute. The ruling goes in favor of the government. Aggrieved, the respondents challenge the ruling, decide the maintainability of the challenge before the High Court. Now, this is a petition which is maintainable. What is it saying? It says, once again, it says this more or less the same thing which has been stated in the previous one. But the facts contains a little bit of elaboration. And the elaboration is that earlier Waqf tribunal has already given a finding. Now the new amendments comes to existence. Under the new amendments, the government constitutes a new tribunal and says that revise the earlier judgment. And they go ahead and revise the earlier judgment. This is not allowed. This is relitigating all disputes, which is not permitted. Every law which comes into existence is a law which comes into existence prospectively. That is to say, from here on, it comes into existence. It does not come into existence from a previous date. That is not the way. So this, the government is not competent to. Once the earlier Waqf tribunal had given its order, then your only remedy is you can go in appeal. But under the earlier law, there was no right to appeal also. You can go, of course, you can go in writ. Writ proceedings are still available to you if appellate proceedings are not available to you. But then the grounds would be limited. The grounds would not be as extent as extensive as they are available in the case of a full appeal on merits. This you will be allowed to re-adjudicate the entire issue. You will be allowed to argue the evidence. You will be allowed to assess the merits of the case once again. The appeal is a continuation of the proceedings which have been undertaken in the courts below. Therefore, that kind of thing will be allowed to you. But in case of a writ proceeding, lesser considerations, fewer considerations will be before the court, which are considerations of procedure, that by right to hearing was violated, that principles of natural justice were not observed, that the findings are perverse, that the findings are beyond the jurisdiction of the tribunal, and like this, right? Which are slightly on the procedural side, whereas in the appeal they will come on the merits. Once again, the entire matter will be re-adjudicated, reheard, but then the evidence will not be taken again. Whatever evidence has been taken will then becomes final. Facts will not be taken up once again. That finishes the discussion or this thing. Tomorrow we will take up the 61st mock paper. And if you require another mock paper, having finished the earlier one, please let me know so that I can forward another one to you.
Sir, forward me next month.
You have to be forwarded the 63rd mock,
64.
64. All right, 63rd I'm going to forward it. All right, better that tomorrow we see you once again. Just understand one thing, that this board business will be a slightly tricky business. So give us some time. We are trying to resolve, because in mathematics will require a lot of board work. So we'll try and install a smart board. We haven't installed because I never needed that board. I have a Socratic style of teaching with my students, so I don't really need any board. My students, I immediately come to know if my students have understood or not understood, provided they cooperate. If they don't speak what I ask them to speak, then I don't come to know. Otherwise, generally they speak, and generally I come to know. Anyway, so please bear with us a day or two before this board business gets sorted out. Nevertheless, sir will take your class with whatever limitations to. Okay. Sure. And what about you, Rare? Do you want the paper to be forwarded to you?
Yes, sir.
Which one is this?
61.
60. All right, I'll do that. See you again tomorrow at the same time. 2 o'clock. All right, bye-bye.
Dear students, GPS CLAT Academy at Gyanodaya, a senior secondary school at Sikar, supports its students in their CLAT preparation. We have started a lecture series which will be delivered to you on a daily basis on YouTube. The lecture series revolves around discussion of mock papers. You can request us for the concerned mock papers. If you intend to join us in our daily discussions, you are most welcome.